Hey everyone, Rob Ryder. We meet again. What is today? The 14th? Yeah, April 14th. Tomorrow's tax day or something, isn't it? That is just wonderful. Excellent. So, this really isn't about notaries, but I just wanted to point something out. This is the Notary Public Handbook for the state of California, 2013 version. And, quiz me this. Look at the table of contents. And you go low enough and you see they got things in here about the penal code, probate code, commercial code, election code, civil code, a procedure, civil code, government code, a penal code, felonies. Right? Why do they have these sections about the penal code, which are very good to know because these are really the things we want to point out? They're in your notary handbook, unless the notary is supposed to be able to use the power to point it out. That's great stuff. Anyway, so what this video is really about is, taking things been learned in the past, how are you going to use it today? A lot of people like to do this stuff because they like to research. And the more the research, the more they find, the more stones they turn over, and it goes on and on and on and on and on. It is quite interesting. But the thing is, what are you going to do with the damn information? Right? So I'm much more interested in doing than researching, although I'll do the research to find what I can go do. So one of the many things is this is the IRS 6209 manual. IRS 6209 2013 version as a PDF. Google it, you'll find it. If you go to page 25 of that 236 PDF, because normally it doesn't take long to get the truth out. So this from the IRS, and what's this going to show? It's going to show the tax class of all the different forms that the IRS uses. So for instance, a W-2 is a class 5 tax class. There's a tax class, right? W-2, class 5. 2C, 2, CM. By God, look at that. All the W-2s are class 5. That's interesting. And so are the W-4s. They're all class 5. Got lots of class 5s in here. I wonder about 1099s. What do you think the chances are that a 1099 is a class 5 gift and estate? Let's see. You go far up. There we are. Well, look at that. All of those are class 5 gift and estate. And you're going to have to excuse me. So, where was I? There we go. So the question is, if all this is class 5 gift and estate, why are we paying tax on it? Why don't we put it on the gift and estate line on a 1040 form? Better yet, why didn't we not use the 1040? And I think it's the 1041A we're supposed to use. USA information return, because that form is an information class 5 gift and estate. And so none of this is not known. Bobby in Arizona has called the IRS, had it confirmed to him. It's all true. Went to his accountant to have him redo all of his forms. The guy said, I've been at this 30 years. I'm not going to do it any different. All right, so again, evidence is there. What do you do with the evidence? In fact, for myself, right, this is really what got me into this. Is I heard Gene Keating talk about this two and a half years ago, about this class 5 gift and estate in this book. Went and looked, sure enough, there it is. So I wrote the IRS and asked them for an audit. I wrote them twice. I said, I want to have an audit because I made a mistake. I thought it was income, but apparently it's class 5 gift and estate, and I should have put it on a different line on the forms. And since the mistake goes back to the first instance, I've been doing this since I was 16 years old. I need your help. Need you to come and give me a audit and figure out what my return is, and please get it for me. And so they didn't. Then I wrote the Inspector General of the Treasury, and that got me a call from a Treasury agent here in Grand Rapids who came, and we sat for an hour and a half, drank coffee, talked about life. And told me 3 different times, most intelligent explanation I ever heard for why a man believes what he believes. And he also told me, you really shouldn't write any more money orders, because I had, and when they showed it to me, I said, well, when they said, is this your money order? I looked at it and said, well, no, mine had a blue ink signature. It was accepted for payment, wasn't returned. I'd like to know where my check is. He says, well, you wrote it for $2,000. How much was the bill? I said, about $450. Well, why'd you write it for $2,000? Well, because they're just a bank, and I needed some cash, so I was going to cash out some of my estate. So, none of this stuff is crazy to them, man. And when you talk to them, they'll tell you things. And so, because I've looked at this differently than a lot of people, I've got a lot of different phone calls and things told to me and learned things, such as with the right person, right judge, if you say, I accept your oath, bind you to it, remind you of fiduciary duty, right? He's going to get you off the hook. Happened to a guy here in Michigan on an IRS case. That's all Doug said in court. He didn't have to go any further. I accept your oath, bind you to it, remind you of fiduciary duty. Oh, and I extend you my sovereign immunity while carrying out my orders. I think he put that at the end. And when the judge's draw finally got closed again, he said, why don't you go have a seat in that room over there and we'll send this IRS man in just a minute. And the IRS man showed in just a minute, and what he really wanted to know is, what did you say out there? But then he got to the point, look, just write me a letter and I can make this go away. And they discussed what was going to be in the letter. Letter was written, away it went. Pleas of the Crown put into court cases. Well, here's an interesting thing. Now, we got our friend Rich up in Alpena. He had a hearing a week and a half ago for a federal warrant. And so that's the one that I did the video on, where we put in a complaint. The judge had it in his hand during the court case. Mentioned that for him to see anything, he had to be motion of the court. Rich kind of messed that. But he also, he says, and you must demand a preliminary hearing, which has been set up. It's supposed to have been 2 weeks, which would be this coming Wednesday. Demand a preliminary hearing, because that's where the evidence is heard. And so if you've heard the stories before, I'm not going to go into more detail on that, but the thing I wanted to point out was they gave Rich a copy of the warrant. So they say. And it was dated 2 days after he was put in jail. And it has the guy's signature on there as the complainant witness. But what he didn't tell me till yesterday was he's got the original blue ink signature copy. And it's like, oh shit. They gave him the evidence. And if you were to do like it says in the Michigan compiled laws for a traffic violation, something else I've pointed out here recently in a video, it says if an officer gives you a citation and you just write on it, you deny the charge, basically, and you sign it and give it to him, right? Now he has to put in a sworn complaint. Up until then, it didn't need to be a sworn complaint. It would have just been a promise to appear. And if you promise to appear and then don't appear, then the clerk of the court will say, well, you promised to appear and didn't show up. I'm going to swear an oath or swear a complaint out against you and put it under oath. And now you're going to go in because of failure to appear. So, but if you write deny on it, or denied, or words to that effect, now the police officer has to put in a sworn complaint, and they never put in a sworn complaint. They're at best a complainant witness, but they're never the complainant. And the next section goes on to say that if a police officer makes a false statement, it could be a 15-year felony for perjury. Now, perjury is supposed to be 5, but they said 15 very clearly in Michigan, so it's more than just perjury, right? It's almost like, I don't know, petite treason, something along those lines, usurping the powers of an office, yada, yada, yada. Something that way. So, okay, so back to what's going on. So here a few weeks ago, I got a love letter from the IRS, right? And I've gotten these in the past before, and they never call me, never talk to me, they just send me stuff. Got one certified mail. And so on the address it says Internal Revenue Service, gives the address. But then it's interesting that, somebody always, I don't know if they always do this, but under that there is a blue ink set of initials. It was sent certified mail to Robert A. Rytlewski, all caps. Not my middle name, my middle initial. Well, that's a fictitious entity. It doesn't exist. I think they're using the mail for mail fraud. I think I'm going to put a complaint into the post office. But who in particular? Well, let's take a look at this. So that's what I'm doing, right? Here's a way to do a criminal complaint, possibly. You got an IRS issue? Somebody else sending you mail you don't want? So that's what I'm going to go put in. To the post office inspectors in charge. I'm the complainant. My real full name, my street address. I'm not going to call it my mailing address. I don't know what my mailing address is. All I know is that's the street address. The city and state, United States of America, my phone number, the respondent, and then, pursuant to the Code of Federal Regulation, Title 39, subsection. Anybody know how to make those two S's with your keyboard? What's the one to make the double S? 50.4300, inquiries and complaints. 1. Rytlewski Robert Allen, as complainant, by the sworn complaint, informs and makes known to said post office inspectors in charge of violation of the following sections of Title 18 of the United States Code by the respondent, its principals, officers, and agents. Particularly 18 U.S.C. 1342, fictitious name or address, or 1342, and 1341, frauds and swindles. All right, let's take a look at what those say real quick. Here's the fraud and swindles, but first of all, we got to get them for mail fraud. Okay, so 18 U.S.C. 1342, fictitious name or address. Whoever, for the purpose of conducting any scheme mentioned in 1341, fraud and swindles, or any other unlawful business, uses a fictitious, false, or assumed name or address is guilty of 5 years. I don't need to read anymore. They're guilty of mail fraud. They used a fictitious name and a fictitious address. And then you can go read 1341 because they're tied together, and basically they commit fraud, imprisoned for not more than 20 years. Unless it's in violation of any benefit from a presidentially declared major disaster or emergency, like a national emergency. How long have we been in one of those things? Well, then it's for 30 years. I don't think they're playing around. So, there's the two codes they're breaking. And the evidence is the fact that they've mailed the mail to, all caps, Robert A. Rytlewski. There is no Robert A. Rytlewski. It's a fictitious name. There's a Robert Allen Rytlewski, whose real and full name by operation of law is Rytlewski, space Robert Allen. But I'm Robert Allen, son of God. That's my given name. Right? So they're guilty of it. Or I'm saying they are. And the addressee, me, named on the provided evidence, identified by certified mail tracking number, which I have, is a fictitious entity. And I believe the address of the addressee is a fictitious address, not authorized by the postmaster in accordance with Domestic Mail Manual, which D041, Customer Mail Receptacles, 2.3, Address Identification, subsection B, a house number, if street names and house numbers have been assigned by local authorities and the postmaster has authorized their use as postal address. If a box is on a different street, yada yada yada. It is my belief that the postmaster has not authorized the use of a house number and street name as the postal address necessitating the use of certified mail by the respondent so as to require delivery to complainant in personam, simulating the receipt of a summons as part of a fictitious court proceeding. They actually just sent you a summons when they do this by certified mail, in my opinion. Right? They don't put it in your post office box. Either the postman delivers it to your door, he just is serving you a summons, or you go down to the post office to get it up because they sent you a card. Right? You've just been served. It's part of a court process. It's a court proceeding. But because it has a fictitious address, being the street number and name, and it hasn't been authorized by the postmaster, right? They don't put it in your post office box. Otherwise, they could just send it to you by normal mail. Because, something that's put in the mail is considered delivered, period. Once it's in the mail, it is considered delivered. That is a presumption of law. That's why in a court case, right, when you put in a certificate of mailing, you don't need to say you sent a certified mail. You could just say you put it in the mailbox. Most people send them certified mail, I understand, but it ain't what you say it says you have to do. You can send it first class mail. That's good enough for the court. Right? If you get to court and they say they didn't get a copy, well, then the court will say, well, here's a copy. Now you got one. Right? Or I'll give you one right now. So what they're doing is they're treating you like they're serving you just in personam, in person, going to serve you a complaint, hidden by this thing called certified mail. The fictitious court proceeding in rem, and it's in rem because it's going to be against your all capital letter name or some variation of it, which is the property. That's the defendant. And in a civil case, in a property dispute, the best you can be is pro se litigant, which makes you the property's attorney. But the property is the defendant. That's what in rem is. In personam is when it's the normal upper lowercase name. That's against the person, the natural person. In rem, it's against the legal person, or the name of the property, or the name of the estate, or whatever you want to call it. To me, it's an estate. So this fictitious court proceeding in rem, and why is it fictitious? Well, because nobody's filed a complaint under oath, uses threat, coercion, and duress, and conspiracy of unknown others with the respondent, utilizing false and misleading statements to swindle property and unjustly enrich others by a willfully false judgment and the perjury of witnesses to enforce an illegal contract. There is no evidence of any bilateral contract between the complainant and the respondent, and unilateral contracts are not lawfully binding absent consideration of equal value. There is no sworn complaint by respondent to substantiate its claims. IRS Processing Codes and Information Manual, the one we looked at, IRS 6209 for 2013. Section 2, Tax Returns and Forms, identifying the tax class of all tax returns and forms, clearly states that W-2s, W-4s, 1099s, and many other are specifically for Class 5 gift and estate issues, not income. I demand an information in the form of quo warranto to investigate the corporate charter and franchises of the respondent, oaths of its principals, officers, and agents to determine the validity of authority or violation thereof. Upon violation found, a court of competent jurisdiction is to put the said respondent into receivership. It was never my intention to gift or donate my property, and I demand its return along with any gains now unjustly held by unknown others or the respondent. I guess I'll add that in there. It is my belief that the respondent is an enemy of the state, a nuisance to the public, whose daily breaches the king's peace by the traitorous acts of his principals, officers, and agents. Whatever day it's going to be, me, and then take it down to the postmaster and say, I want to put a complaint in to the post office inspectors in charge. And that came out of this Code of Federal Regulation, Title 39, subsection 50-4300, Inquiries and Complaints. It says you give it to the postmaster inspector in charge. Okay, so I'm going to go down and have my postmaster put her jurat on here, give them a complaint. give them the evidence. This unopened piece of mail with a certified mail number on it showing that the respondent is using a fictitious name through the mail to commit mail fraud. So that's something you could do. You got an IRS issue, ask me what to do. I just told you, right? You got a credit card issue, ask me what to do. Just told you. Somebody's sending you mail in your all cap letter name. Put together a complaint very similar to this, whatever words you want to use. You're pointing out 18 U.S.C. 1342, 1341, the fact that the name they're putting on there is your all caps, is a fictitious entity. They're guilty of mail fraud. And it's part of a conspiracy to take your property. Well, now it's fraud and swindles. And let the post office handle it. So, and then I did one other thing. So, when I was talking to Tom yesterday, he's contacted. See, we're trying to figure out who this in between justice of the peace is supposed to be. Looks like it could be any notary, if they know it. But if the judge sitting at the district court, the traffic court, the court where all the criminal proceedings start, is the trier of the fact, and in history, when you read what happens, the justice of the peace was supposed to take the complaint, and if probable cause existed, go to the trier of the fact to determine if probable cause existed. If there was, the trier of the fact would issue a warrant or a summons, and that was all in the video from yesterday. So we're trying to identify who these, justice of the peace are. So here in Michigan, it should be the county commissioner. It should actually be the township supervisor. However, Article 7, Section 7 of the Michigan Constitution, right in the footnotes of the section, says that it's unconstitutional by the federal Constitution. Go figure. Michigan has an unconstitutional constitution. And they admit it right in the damn thing. So what they did is they got rid of the townships and they district by population, and that's why you have these different districts with about the same amount of population. This even goes to the Michigan Courts of Appeal. When you look at their jurisdiction, their territory, it's all different sizes, but the populations are the same. It's all based on population, so that one man has one vote. Now, that shouldn't matter if one man had one vote, but what they're saying is one man is going to vote for this many people, so they should have the same number of people underneath them. That's the way they're trying to use it. This one man will have the vote of all these other people when you're represented. We don't want to be represented. We want to go back to the republic. General elections where we vote for the president, we don't vote for someone to vote for us for the president. Because in the republic, you're not voting for your president, you're voting for the president over the democracy. You're his peer. You're there to make sure he does the right thing. That's why you gave him the job. Take care of the democracy. The sheep will need someone to watch over them. Right? Tend to them and let's bring them along. Wake them up. But we've allowed evil to take over the system. And if you don't believe that this is a war between good and evil, you're crazy. Go back to sleep. Or go dig a bunker and start counting your ammo. It's just a matter of faith between good and evil. Right? And we're supposed to be an antichrist, another Christ, and go and point out the transgressions. And the civil government's in place through these justices of the peace to handle the problem. It's weighted in our favor so crazily heavy, it's unbelievable. And it's going to bear itself out, I have no doubt. So anyways, I wrote this too because one person they talked about being very important was the magistrate's clerk. And the magistrate's clerk took over the administrative functions. And then, of course, you see that all these different courts have court administrators, which I believe is the judge's clerk, the administrator they're talking about. So I wrote this to Kevin, who I've talked to before at the local district court. And I got this out late Friday, so he hasn't seen it yet. Or maybe he did, but I didn't expect him to answer. So, hello, Kevin. I have a question on who is qualified ex officio as a justice of the peace authorized to submit my sworn complaint to the trier of the fact. It's really what I want to know. Who do I go to first so that it can be submitted to the trier of the fact? It appears as a two-step process for submitting a complaint of crime into the chancery equity side of the court. First, create a bill of complaint as the complaining, providing the who, what, when, where, and why, and evidence to substantiate the claim, and take it to a justice of the peace where an oath is administered. Second, the justice of the peace, as the public's prosecutor, has a probable cause hearing with the trier of the fact, and if possible, or probable cause is found, the trier of the fact issues a subpoena or arrest warrant against the respondent. I'm sorry, that's how it reads that it's done. That's all you need to do. And in the Michigan compiled laws, a magistrate shall issue a warrant upon presentation of a proper complaint alleging the commission of an offense and the finding of reasonable cause to believe that the individual accused in the complaint committed the offense. The complaint shall be sworn before a magistrate or clerk. Well, there's his clerk. They're talking about the magistrate's clerk. But who's a magistrate? Well, from what we found out yesterday from the United States Supreme Court, they said a notary is ex officio a justice of the peace. Okay, so the respondent can admit guilt or deny. If they deny, they can submit to the verdict of a jury or choose to participate in judicial battle with my champion. As the Chancellor of the Court of Chancery in Tennessee famously quoted, "To defy the Court of Chancery shall bring the thunderous wrath of the Vatican upon you," so I like my chances. I'm trying to identify my local officer that is ex officio a justice of the peace. Looks like it could be a mayor or someone appointed by ordinance or resolution. Could be the county commissioner, the guy that's over these districts, as these districts now make up the local government, having replaced the township supervisors, evidenced by the unconstitutional provisions of the state constitution of 1963, which says, Section 7, section held invalid under federal constitution. That means unconstitutional. And if you were to read this advisory opinion, I did a video on it, explain what it's all about, but basically it had to do with redistricting based on population, not on territory. And when they did this, that these new districts would have the powers of the township. So the township supervisor is who we're supposed to be appointing as our agent, and the board as our counsel, agents and attorneys, to handle the affairs of our business. It's where we go and domicile our legal and natural persons. Things we tried last summer without much success, but some pretty interesting stories. And it's just the wrong office. So Tom is contacting his district attorney or his district county commissioner, and I'm trying to contact the court clerk. And we'll see what we get next week for answers. So, and it appears for the, should have probably been from, the advisory opinion that these newly formed districts, headed by county commissioners, took over the powers of local government. Kind of important to know if you wish to be a registered elector in a municipality versus a registered voter of the state, and appoint the supervisor and board as my agents and attorney, which is what this did in the townships. Inhabitants of organized townships as body corporate. Powers and duties generally, acquisition of property, public purpose, suits, acts, or proceedings, supervisor as agent. The inhabitants of the organized township are a body corporate, not a body politic. Don't want to be part of anybody's body politic. We want to reject the body politic. And have, in addition to other powers that are conferred, all the following powers and duties: to sue and be sued and appoint necessary agents and attorneys for the purpose. Supervisor of the township shall be the agent. Bingo! I want to appoint the supervisor my agent. It's called the power of appointment. Or is it just a local notary? And if so, do they log my complaint and mail my sworn complaint to the trier of the fact, maybe via the trier of the fact's clerk? Can I fax or email my complaint to you and have you swear me in over the phone by attestation? Because they should be able to do that. I have many complaints about the current state of affairs, not the least of which is an unconstitutional constitution. Here's a short list. Most of the civil proceedings are simulating legal process, as there is no sworn complaint by the complainant, only a complainant witness. This could only lead to a willfully false judgment or perjury of the complainant witness. Yet citizens of the United States of America are subject to threats, coercion, duress as part of a conspiracy to enforce illegal contracts under color of law in a suit that has a legal fiction, my property, as the defendant. A traffic ticket is a promise to appear, not a sworn complaint, and if this fact is challenged, the attesting officer faces 15 years because he's not going to put in a sworn complaint. Various statutes allow unconstitutional statutory liens not recorded, noticed, or delivered to be used as instruments of fraud. Real estate transactions are purposely not closed, and the fee simple title guaranteed by the title insurance has not passed the grantee of the warranty deed. The title insurance company has a duty to defend the fee simple title and is derelict in their fiduciary duties. Securities are withheld that by law are to be returned to the mortgagor upon satisfaction of the underlying debt, the debt being some fictitious loan not evidenced by any recorded lien. All men the age of majority are to take an oath of allegiance and have it filed for record, and be issued a certificate of citizenship upon which their permanent residence, municipality, is to be listed. This is then evidence for the holder to register as an elector in his municipality, appoint his agents and attorney to administer his property and execute his orders. They're going to be your executor and administer your orders. We just need to get our domicile in the frickin' municipality. The township or the district is a body corporate, not a body politic, as the county is. The county as a body corporate claims to property. You can see I did this in a hurry. Body corporate claims rights to property of its inhabitants. Where in 45.4 of the Michigan compiled laws it says, all real and personal estate heretofore conveyed by any form of conveyance to the inhabitants of any county or to the county treasurer or governor of the late territory of Michigan or to any committee, trustee, other person for the use and benefit of such county shall be deemed to be the property of such county. But it started out by saying heretofore conveyed by any form of conveyance to the inhabitants of any county, comma, let's pick it up with the next one, shall be deemed to be the property of such county. And all such conveyances shall have the same force and effect as if they had been made to the inhabitants of such counties by their respective corporate names. Basically, if you're an inhabitant in the county instead of in the municipality, you became part of their body politic, and because you're part of their body politic, you threw your property into theirs and they're going to administer it for you. That's why you don't want to be an inhabitant of the county. You want to be an inhabitant, an elector, recognized as having your domicile in a municipality within a state. You're a citizen of the United States of America and the several states, not a citizen of the United States of America and the state of Michigan. I don't want my residence to say it's Michigan. I want to say it's within Michigan. Rockford, Michigan is within Michigan. It just happens to be the state I'm residing in, but I'm a citizen of these several states. As I said, I'm a citizen of the United States of America and the several states, not a state citizen who is being denied my God-given right to immigrate from the democracy into the republic, and that is contrary to my law, as is coveting someone's property, and that, dear reader, is coming to an end. So, Kevin, can you help me out? Your trier of the fact told me last year in video court, it's not that you're not correct, but I'm not inclined to issue any warrants, but you can appeal my decisions to the circuit court. During the discussion of my last attempts via pleas of the Crown to find justice from the one court of justice. The only appeal I could possibly make to the circuit court would be for a willfully false judgment and perjury of complainant witnesses into the circuit court in and for the county of Kent in Chancery, when all I really want is justice. Oh yeah, one more complaint, chemtrails. Can we file a complaint against the FAA for allowing them and call out the Air Force to stop them? I'm sure your family would be as grateful as mine. Boom. I just sent that as an email. Let's see what Kevin has to say on Monday. So, there's plenty that people can do. Please do. Right? Go ask a damn question. Find out who the justice of the peace is and how you get a frickin' criminal complaint before the trial of the fact. Under oath with some evidence. There's no lack of evidence. For God's sakes, just go watch the videos I did. It's laying all over the place. No court seals. No frickin' improper summonses. Improper complaints. It's all fiction. Point it out. But as Bouvier says, you can't expect a civil remedy if you're not willing to point out the crime. So, okay. Y'all have a great day. See ya.